You tested negative.
Well, thank you.
That's fantastic, and it makes me very happy. So look, just be good. That's all we're asking, okay? Nothing's going to happen to you today. We'll just give you a reset and just be good. Don't pick up a new case.
Monitor. It's very tight. I'm not a flight risk. I'm not going to be, I won't go around that area. Everything else, and
You're telling me I can trust you?
yes, you can. Judge.
I know, I saw it.
And it's really cut, like, it hurts. It's like they put it real tight to the point it's like getting into my ankle.
Corey.
Yeah. Yes.
Take it off.
Thank you.
Just be good. It's not hard. Make the right decision when you're out there. You pick up a new case, a third case, I'm going to lose it.
Okay.
You understand?
Gotcha.
Just be good. Talk to.
Welcome back to Court Watch, where today's docket is a roller coaster of second chances, strict warnings, and some surprisingly creative sentencing. Right off the bat, we see Judge Fleischer showing compassion, removing a tight ankle monitor and giving Corey what's called a reset. That's basically a legal pause. No punishment today, but with one crystal clear condition: stay out of trouble. Sounds generous, right? But here's the catch: one more slip up, and the judge promises to lose it. That's the razor-thin line between freedom and jail time. And this isn't the only tense moment. Later we see a man accused of assaulting his partner, a protective order handed down, and even a theft case where the judge swaps community service for a parenting class. So stick with us, because this session shows every side of courtroom justice: mercy, hard reality checks, and some unconventional sentencing twists. Let's dive in.
Corey, whatever, doesn't matter to me.
Okay.
So Alex, if you can file, no going to target, please.
Sorry, just that particular target or all target? Yes.
I'm doing it right now.
Okay, thanks.
All right, Judge, next is page 19. Ridley, come on up. Yeah, that's fine.
Good morning, Mr. Ridley. Sir, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 29, 2024, officers were dispatched to a disturbance in a weapon at a residence in Harris County, Texas. The officer observed the defendant standing in front of the complainant vehicle, preventing her from driving away. The officer made contact with the complainant, who stated she and the defendant have been in a dating relationship for about 2 years, and the complainant stated she and the defendant got into an argument in his residence after he mentioned something about her children. The complainant stated she decided to leave and got in her vehicle, where she stated the defendant wanted his belongings out of her car, and the defendant had placed some of the groceries she bought on her car at some point. They were arguing and attempted to break her driver's side window. The complainant stated she rolled down her window to prevent the defendant from breaking her window, and that the defendant reached into her vehicle and struck her in the left side of her face with a closed fist while she was sitting in the driver's seat. The complainant stated the defendant hit her in the left side of her face several times and that she felt pain.
Wow, did you catch that? The judge doesn't mince words here. Any violation of that protective order, even something as small as showing up at the victim's house, could land Mr. Ridley in jail. This is one of the strongest tools courts have in domestic violence cases, because it sets an immediate boundary with zero wiggle room. What's even more telling is when the judge asks about school and work, calling out the defendant for not being enrolled or employed. That's a powerful point. Idle time often leads to destructive choices. The judge basically says, get a job or get back in school or else. It's not just about punishing past behavior, it's about forcing a path forward. What do you think? Is the judge being too harsh, or is this exactly the tough love needed to prevent a repeat offense?
A protective order has been issued in this case. I would get to know it. If you do something to violate this protective order, like go to the protected individual's house, have any contact with her. If you're in possession of a weapon, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. Do you understand? So get to know it and don't smoke any dope. Don't use any alcohol. How old are you? What do you do for a living?
I go to school at it right now.
Where do you go to school?
I was going to Summer Creek High School. My friend enrolled in Houston Kansas Academy.
So what are you doing now? Are you doing nothing with your life?
No, I go to school, but
No. Are you actively enrolled in school? Yes or no?
actively not right now, but
So that's what's going to happen now. I'm going to provide you a lawyer. You must either get in school full-time or get a job full-time as part of your bond conditions as well. Do you understand?
not the reason I understand, but the reason I ain't in school, right?
Don't matter. When you have too much time on your hands, you become self-destructive. We need you to do something with your life so that you become something of yourself and with yourself, because you turn 40, 50 years old and you ain't got some kind of education or some kind of trade or some kind of working knowledge. You're going to end up on the street, no money. And this life sucks without money. Do you understand? If you don't believe me, go look in the jails. If you can provide him a lawyer, same thing. Hold on, not done. We'll set out 2 weeks, see where we go on, and then no dope, no alcohol. All the jazz and no weapons. All right, come on.
Go ahead and sign for your receipt.
Stephen, you still have Gerard back there, right?
Yes, sir.
I need him one more time.
Lori's back there talking to Rubio. I'll let her
Please,
know.
because we just need to do the enhancement. So, yeah, I need Lori too, sorry.
No problem.
Yeah, so you kick the assault, but we need to keep the theft because that's what makes it the I'm sorry, we have to do the enhancement
The pleature to
just to the theft because that's what makes it the actual B. Sorry. Hi.
I'm here on Marvin Opute.
Okay, I see it.
I'm looking here, we're still pending a writ for restitution. I didn't realize that they're still reviewing packets for PTI, so we'll be submitting.
It's 190 days old. We got to get on it like really quick. How long is it going to take?
We can get a packet in within a week.
Done. And then do you guys know about the RIP? How many times you've attempted? It's on Opute, please. Yeah, because it's 190. It should have been,
Oh,
yeah. Tell me about the RIP, please.
We're still working on the writ, but we just understood this one as a wheel witness, not as the person directly involved in the crash. We can get that done right away.
Okay. I'm going to set it off a week and then he's got to get the packet in. If it's not in by the week, I'm bringing here day after day until he gets it. Okay?
Yes, Judge.
Okay. Top of page 17. Thanks. Mr. B.
approach, please.
Yes, sir.
Judge, I need your wisdom on a matter. I was just appointed to a Miss Jessica Sanford. Mrs. Sanford is the defendant. She was residing with the complaining witness in this case. She has a medical issue that involves where she's going to have surgery. She has some personal implants and stuff that's currently leaking, and without getting it medically taken care of, it could result in infection.
Come up, ma'am.
And I'm trying to get her keys and stuff so that she can have her ID for purpose of hospitalization.
Where is it?
It's with the complaining witness in the case. we have a no contact order, well, we don't have a no contact, it's just no threat and
No. I did no contact because they've,
contact.
well, the reason is because they've not been able to, speak to the complaining witness, and I don't know what the complaining witness's wishes are.
Yes, sir.
So until I know that they want to have contact with you, we do no contact. And I do that not just on your case, on every single person's case.
That's
Because
correct.
I don't know what their wishes are. What if they don't want to have contact with you, right? So until I know, now, if you can make it easier for them to be able to get in contact, and the state can, and they find that it's okay, then I'm all game, but I have to know what their wishes are. So they're gonna attempt.
I'm here for my help right now.
I get it, and I never want to do anything to prevent you from getting help, but remember, you can also try to use another friend.
I have nobody here in Texas. I'm not gonna let that have contact with anybody.
You can have contact with anyone you want.
When I was in the relationship with the.
I don't want to talk about the case.
I haven't been allowed.
My only concern is the wishes of the complaining witness. So I can have Alex go out there to try to call now, but if they're sleeping, they're at work, if they're not answering, it may take some time. Perhaps maybe tomorrow. I don't know. Do you mind?
I don't mind, Your Honor. I just, if she has a number that we can.
One, two.
Okay.
Yes, I can provide.
So let's see that you guys get together, see what you can do. If you are able to make contact, see if she's okay with having contact, or we'll go from there. Okay. Hey, guys, one more thing. You guys filed 2 motions in limine on Perechu. Is this a trial case? And then have you spoken with the defense? Morgan,
Morgan approached me to put those in your queue Friday, but I don't think they approached you.
yeah,
I'm not sure.
I guess, let me see, 254. 2544848.
Okay.
Ricardo, this is your case. Yeah,
I think it's disclosures, no?
no,
No?
no, this is, are we separate trial?
No, I don't.
He is
That's the one I was
separate
looking to plea out. He's in custody.
She filed motions for 2 states motions in limine.
I think they're related to disclosures. I think they were filed at the same time as the disclosure.
Maybe it's done by mistake?
Possibly. I didn't give it much thought because it was just, I think we talked about it. It was just disclosures. We're not heading towards trial now.
Is it true or untrue that you had that prior theft?
So,
Okay, that's all we needed. Thanks. All right, so true to that enhanced. I don't have Morgan's number to call her.
Is Morgan still-
She's in DVD.
She's in DVD now. I guess, you know what? I'll email her and I'm gonna attach you to it, and then,
I don't think it's a big issue.
She probably just did it preemptively.
Howdy, Your Honor.
hey,
Happy New Year. How are you?
Happy New Year. How are you, man?
I'm good, man. I didn't get moved to your floor, but I'll be moved soon from floor 11, so I'm gonna get used to that. I'm a Mac appointed attorney, so.
Okay, great.
Yeah.
Well, we'll look forward to having you.
Yeah. So I'm here, Your Honor. Looks like there's a bond violation report this morning on Kabir, K-A-B-I-R.
Is Kabir here?
No, and that's why I wanted to approach you, Your Honor. I'm gonna call myself here at the, I didn't, my client, I'm used pricing on floor 11. They pre-trial their text them their court date, so I kind of just assumed that he knew. I should have reached out. That's my fault. If we can.
Well, let me see. Hold on, because if he knew that he had to be here and he's not here, we're gonna have issues.
The violation was filed just this morning.
It was filed this morning, Your Honor, and it was for IID lockout, not he has scram as well. So
Let's do this. I'm gonna put him on for Friday.
That's fine.
Gotta be here Friday. If he fails to appear, then, and then if you don't mind reaching out to him.
Yes, Your Honor.
Yeah.
I'll do that
Okay.
right now.
Thanks. Mr. Salinas, do you want me to print you out a copy of the bond violation report?
No, they emailed it to me this morning. Thank you.
It's okay.
Right.
Okay, try to call right now.
Council for reset?
Sir, take the hood off your head.
That's what I'm saying.
Good morning. Happy
Hi,
New Year.
Mr. Newley. How are you?
Yes, sir. Fine.
See you.
We have to play him out on a 12 months deferred.
Shh.
12 months deferred.
What's the name?
His name is Mr. Arias. Arias Rangel.
Good morning, Mr. Arias Rangel. Sir, you were charged with theft. You were facing up to 6 months of jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you a 12-month deferred. That is a type of probation that if you successfully complete, you do not end up with a conviction on your record. But you cannot tell people it was dismissed. It was not dismissed. Shh. You merely took a probation and completed it successfully, and you don't end up with a conviction. Do you understand?
Yes.
You also need to understand that you give up many valuable rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty and once you accept this probation agreement, you were stuck with this until you complete it successfully, or if you get revoked. Now, I told you that the great thing about this probation is that if you complete it, you don't end up with a conviction, but you give up nearly every right known to man by entering into this agreement. If you violate this agreement, I can put you in jail for up to 180 days. Do you understand?
Yes.
If you pick up a new case, if you don't do any classes on time, if you do not do your community service, we will issue a warrant for your arrest, put you in jail, bring you back out. And if they prove to me that you violated it, you're looking at 180 days. Is this what you want to do?
The probation?
Correct.
Yes.
How do you plead to the offense of theft? Guilty or not guilty?
Guilty.
I will not find you guilty now. I will withhold that for 12 months. To successfully complete this agreement, you must do a TRAS, which is an evaluation to see what other conditions you may need. He's done a TRAS.
Yes, idiom, low risk.
Okay. As part of the agreement, you will do thinking for a change, an anti-theft class, Do you know if he has children? Mr. Newley, does he have children? Do you know?
Yes.
Okay, instead of the community service, I think that a parenting class is probably better, you know?
Thank you.
I will make you a deal.
And there you have it, a full spectrum of courtroom drama. From Corey getting a second chance with that ankle monitor removal, to Mr. Ridley facing the tough reality of a protective order and life lessons from the bench, and finally, a theft case where the judge showed creativity by ordering a parenting class instead of community service. This isn't just about laws and punishments, it's about judges trying to shape lives, sometimes with mercy, sometimes with strict conditions, and sometimes with outside-the-box solutions. So now I'll ask you, do you think these rulings strike the right balance between accountability and rehabilitation? Or should the system lean harder one way or the other? Drop your thoughts in the comments. We want to hear from you. And if you found this breakdown as eye-opening as we did, hit that like button, share it with a friend, and don't forget to subscribe to Court Watch for more jaw-dropping courtroom moments every week.
Yeah, like the dish that you're making, you wanted to do.
You know, I guess, yeah, do the EDM instead of thinking for change. You can roll. You can roll.
Okay.
Sure. No community service, that's just. Yeah. Yeah, and then, that's it. Well, I mean, aside from the anti-tap, these guys still do. Okay, hi.
How's it going?
Hey, how are you?
Two on your docket today that I need to talk to you about. The first one is Jordan Stanford.
Okay,
Super old case, Judge. I believe at our last setting, state was going to evaluate to see if they were going to dump it since he has so many felony cases and things going on.
is he in jail?
Yes, sir. Not for this case. but,
Right.
I know the state just kind of needs to take a look at it to figure out what they want to do. If the court is open to setting it for trial now, or if the state needs.
Hey, Kelsey, can you take a look at Stanford, please? It's nearly 300 days. He's got a ton of other stuff. I don't think you've got the eval done yet.
No, eval's not been done, Judge.
Can we do a week and take a look at it and tell me what you guys want to do? We got to set it because he's got so much upstairs that's going to take 3 years to resolve, you know?
And this one is DVD, Ron, but I will.
Oh, is it then? Yeah, if you don't mind asking.
Yes, sir.
Okay, who's your next one?
And then the other one, Judge, is Mr. Jashawn Harris.
Okay,
Judge, did you say 1 week on Stanton?
is he in custody, Harris?
No,
No, on bond?
I believe his appearance this week.
Okay. I mean, it's getting up there.
Yeah, and
By the next setting, we need to know what you,
And that's all I was gonna ask. I think the state is gonna eval it, to see what they wanna do with it. I think we're at a point where it's either they'll drop it or we'll try it.
so he's not interested in PTI? You sure?
I'll talk to him one more time about it in this interim period
If he is, by the next setting, I'm giving you 30 days, but by then it's 185. So he's got to have the packet done in hand if he wants it.
Got it.
Okay?
Yes, sir.
I got it. Okay.
All right, Judge, and that's all I have.
All right. Take care.
Yes, sir. Have a good one.